Okay, good morning.
Haven't seen it in 40 years.
Wow. All right, good morning, everybody. Thank you very much for being here. This is a workshop on government decision-making and open meetings. My name is Ken Alex. I'm a senior advisor to Governor Brown, the director of the Office of Planning and Research, and relevant to this hearing, I'm also the chair of the Strategic Growth Council. John, you want to introduce yourself?
I'm John Laird, Resources Secretary, and also sit on the Strategic Growth Council.
Matt.
And I'm Matt Rodriguez. I'm the Secretary for Environmental Protection here in the state of California. And as I was reminded when I was talking to Michael Strumwell,
So just very brief comments and a couple of observations before we get to some testimony. But before I even do that, we'll have a chance a little later in the day, and you can see on the agenda, we'll have a chance for some public comments. We will have some form of a sign-up sheet for that. We haven't quite figured out the logistics, but Stephanie, are you here? Where's Stephanie? Okay, Stephanie will be back. She's in charge. I should note that we are recording today's workshop in case people want to check in with it later. So just be aware of that. And with that, we probably know where the exits and restrooms, et cetera, are, but we can provide guidance if you need it. This is a serious set of issues that we're trying to come to grips with. The very essential right of the public to have public proceedings and to have insight and transparency, and also the ability of government officials to work through issues sometimes outside of the glare of transparency, which I think most of us would acknowledge does have a role. And over many years, a lot of that interaction, particularly for boards, commissions, and councils, is governed by the Bagley-Keene Act. The Bagley-Keene Act was amended in 2009, and I think you'll hear today from some of the commenters that that has created some additional difficulty and uncertainty that has perhaps given rise to some unintended consequences. And just as you'll hear from a commenter from the Strategic Growth Council later today, but it's been the experience that I've dealt with the most specifically. And I will say that the Strategic Growth Council, which is made up of 7 cabinet-level officials and 3 public members, was set up to break down silos in government is one of its most important functions, particularly around sustainability. Those cabinet officials, before the Strategic Growth Council, were able to talk about sustainability and related issues ad nauseum before the creation of the council to break down silos. Since the creation of that council and the application of the Bagley-Keene Act, their ability to talk to each other is extremely limited, except in the context of a cabinet meeting, which is in the statute as a specific place in which they can speak. It has caused some siloing issues, shall we say, and I think we'll hear some discussion of that today. So I don't want to go on any longer, but let me turn to my colleagues, Secretary Laird and Secretary Rodriguez, and see if either of you have any opening comments.
I just think you summarized it very well, and I just appreciate the irony that in our organization, to break down silos, we can't talk to each other.
I'll just look forward to today's testimony, and we'll be interested in some of the ideas on how we can ensure that our hearing processes are fair, and yet we also have a real opportunity that's necessary to get good information so that the decisions that come out of our hearings and our public processes are really well informed. So that's the balance that we're looking for as we go ahead.
Okay, so without further ado, what we're going to do today is have about an hour of presentations. We'll take a break and have some state agency comment, and then have public comment and discussion. So starting with presentations, Ed, are you first? All right, so our first presenter is Ed O'Neill, Senior Advisor on CPUC Modernization and Reform. And Ed is going to talk to us about some of the work that he's been doing at the PUC and some of what he's been finding. So, Ed, over to you.
Organization, management, processes, and procedures in order to identify opportunities to improve its effectiveness, its efficiency, and its accountability, and to recommend remedial reforms. It is a pleasure to speak with you this morning about the results of the work that I've done in this regard over the last year. As probably everybody in this room knows, the California Public Utilities Commission is one of the most important and powerful agencies in the state of California. It directly regulates roughly $50 billion a year in commerce, but it indirectly affects the state, its residents, its businesses, and its industries in a much more profound way. Indirectly, it touches on the lives of every single citizen in California, every single business in California, every single industry in California. It's dealing with some of the most critical issues of the day, not only for California, but for the nation and essentially also for the world in terms of greenhouse gas and climate change issues. It works in a variety of different ways. It has administrative authority, it has quasi-legislative authority, it has quasi-judicial authority. At any given time, it has roughly 500 formal proceedings pending before it. But it does much that is not done in the formal proceedings. It administers billions of dollars in programs every year that are not in formal proceedings. It's critically important that the commission function in a better, more efficient, more effective, and more accountable way. And that's what I'm going to talk about this morning with you. First, I wanted to briefly mention the methodology that I used. I've been asked to do this task that's really an overwhelming task with essentially a minimal staff. It's myself and one person on loan from ORA.
Welcome to the Brown administration.
So,
now we know where there's a staff member we can poach.
Right, yeah. I did a certain amount of original work along with a woman named Zhen Zhang, who was very, very helpful. But we relied a lot on prior studies and reports that had been done. The PUC has been reviewed in a lot of different ways. We reviewed prior studies going back decades. We reviewed more recent studies about the Public Utilities Commission, including all of the reports relating to the San Bruno explosion, the causes, the direct precipitating causes and indirect, what are perceived as root causes of that incident, prior utility incidents and accidents in which the PUC played some role. We met with commissioners and employees at every level of the commission. We met with some outside stakeholders, somewhat limited though, since I have a better level of confidence that I understand their concerns and some of the internal concerns. We reviewed certain information and data about PUC programs, policies, and proceedings. We reviewed studies relating to other state commissions and federal agencies, and we reviewed academic literature. And based on all of that work, we reached two key findings. There are two factors that contribute most significantly to what I view as systemic problems within the PUC. First, impaired communication, barriers to effective communication both within the executive level ranks of the commission and the working level, and between the executive level and the working level. Second, what we refer to as inadequate governance or enterprise management. These factors permeate almost everything that the Commission does, and they have significant adverse effects on much of what the Commission does. In my view, the agency is never going to come close to achieving its full potential unless and until both of these critical deficiencies are remedied. First, I'm going to talk briefly about the impaired communication. Second, about the enterprise management issues. And then third, I'll get to the remedies. Okay, impaired communication. It is one of the most frequently cited causes of organizational failures in the academic literature. There is all kinds of literature written about all sorts of institutional failures, both government and private, frequently cited as a factor, if not the key factor in these organizational failures, is some form of impaired communication. It's typified by internal communication within the executive level that isn't what it should be, communication between the executive level and the working level that is not what it should be, information and organizational siloing, and what's referred to as informational dissonance. And the informational dissonance is a critical element. That generally refers to situations where the information that the executives, the senior executive managers are basing their decisions on is not of the same nature, form, or type as the information that the working level people on the street are dealing with on a day-to-day basis. This kind of impaired communication can have dramatic effects on decision making. It often leads to not only flawed but catastrophic decision making. And there's an example I want to discuss briefly this morning because it illustrates the problem so well. Former Professor Richard Feynman did an investigation of the root causes of the Challenger explosion. That incident, as you'll recall, was caused by O-rings that failed on joints in what were referred to as the solid rocket boosters. One of the interesting things about the accident is the damage to the O-rings that had occurred on prior launches was well known to the engineers and to the NASA managers. There had been certain burn damage on O-rings on roughly 50% of the prior launches. When Feynman went back, though, to look at the cause, he felt the cause was probably something related to the decision to launch, not the O-rings per se. And when he asked NASA managers what they thought the probability of a catastrophic failure of the shuttle would be, the managers almost uniformly said roughly 1 in 100,000. When he asked the NASA engineers the very same question, the answer was very close to 1 in 200 for every single engineer. The NASA engineers viewed the problem with the O-rings, which was well known to them, as a safety issue. The NASA management viewed the same information about the damage to the O-rings as a maintenance issue. Every shuttle before had been successful, even with some burn damage. Why shouldn't the next launch be successful? The result, of course, was a catastrophic decision. Management decided to proceed with the launch over objections of certain of the engineers, and the shuttle exploded. Incidentally, we now know that the risk of a catastrophic failure for the shuttle was actually 1 in 67. There were 2 shuttles lost out of 5. 40% of the fleet was lost in 135 missions. What does that have to do with the PUC? Well, the answer is the PUC has similar communication deficiencies. They're not identical, but they're remarkably similar. The communication between commissioners is impaired. There is little collaboration. There's little collective debate or discussion among commissioners, even among commissioners on the most important issues before the commission. Commissioners are, in fact, rarely in the building at the same time. There also are significant communication barriers that exist between the executive level of the PUC and the working level. The view among the staff is that the commissioners are more interested in hearing from utility lobbyists than they are hearing from their own staff about technical issues and concerns. There also are communication problems within the agency. Each division tends to kind of stay within its division. And professional staff within the same discipline don't communicate as often or collaborate as frequently as they should. And one reason for this is there is no chief economist at the PUC. There is no chief engineer at the PUC. There is no chief accountant at the PUC. There are individuals in all those disciplines, but they're scattered in different divisions, and they work separately. Communication deficiencies at the PUC have had very significant impacts on the agency's effectiveness. Let me give you an example. It's analogous to the problem that the NASA had, engineers and managers had with the Challenger. The factors that gave rise to the deficiencies in the PUC's natural gas safety program were for the most part very well known to SED. They were known to some degree by CPUC management as well. For example, the SED staff knew that staffing levels were insufficient. They had something like 18 inspectors to inspect 11,000 miles of natural gas transmission, 3,200 small mobile home park and propane systems, and every distribution system in the state. They also knew that new federal requirements required background and experience that they didn't have. They knew they needed training that was only available out of state. They knew that the funding for travel and training was inadequate to get the training they needed. All of those things were known. The commissioners failed to address those problems adequately because they have viewed them as essentially an administrative issue to be dealt with in the next BCP, and if that didn't work, in the BCP after that. SED staff, I am convinced, understood those issues as safety issues, not administrative issues. The result? SED was unable to adequately oversee and inspect PG&E's natural gas transmission pipeline, and it exploded. Okay, let me talk briefly about governance and enterprise management, another frequently cited cause of organizational failures in the academic literature. This generally refers to deficiencies in executive level management over things like the overall mission, goals, and objectives of an organization, and executive level management over things like its programs, its policies, and particularly its priorities and resource allocations. Problems with executive level enterprise management frequently are accompanied by deficiencies in, guess what? Communications and information flow. Information flow frequently is dominated by top-down communication and impaired from bottom-up communication. And we see that at the PUC. There are plenty of manifestations of enterprise management deficiencies at the PUC. There's no integrated strategic plan for the agency. There are, in most instances, very few effective metrics. There's no means of evaluating the agency's relative success or lack thereof, or making mid-course adjustments. The CPUC staff also has no sense of common mission, and they don't have a sufficient understanding of how they could contribute more to the agency's success. This particular problem has also been long recognized. The PUC's made attempts to deal with it before. It was recognized in the Vision 2000 reform effort in 1996. It was recognized and commented on in particular by former Commissioner Mark Farron in his closing remarks before the Commission. Remedies. Let me talk briefly about remedies. Some can be implemented by the PUC and are being implemented by the PUC, but there's only so much the PUC can do. I'm going to leave that for others to discuss. Other key barriers require legislation, most significantly Bagley-Keene Act reform and ex parte reform. The Bagley-Keene Act, as you probably know, prohibits members of a multi-member state body, agency, or other entity from meeting outside of a noticed public meeting open to the public to discuss, deliberate, or decide anything within the agency's jurisdiction. A meeting is very broadly defined as any congregation of a majority of the members of the body at the same time and place to hear, and that's important, to hear, discuss, or deliberate upon any item that is within the subject matter of the jurisdiction. Could you imagine a modern, high-tech firm trying to function under constraints of that nature? Think about what impact that would have on the ability of the organization to act nimbly and to innovate. It wouldn't happen. The Bagley-Keene Act goes even further, though. It prohibits indirect meetings, seriatim meetings. It prohibits a majority of members of a state body from meeting outside of a publicly noticed meeting through a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on anything within the jurisdiction of the agency. What are the effects of the Bagley-Keene Act on the PUC? Well, they're profound. In fact, the Bagley-Keene Act has had and is having a devastating effect, in my opinion, on the ability of the agency to function efficiently, effectively, in a timely manner, and with quality decisions. Discussion of sensitive matters in public tends to be constrained. Candid discussion is almost unheard of on sensitive subjects. As a result of that, the Commission rarely deliberates and discusses in any active or lively way in public business meetings. But given the breadth and scope of what the PUC does, it would be virtually impossible for the Commission to manage all of its diverse activities and responsibilities through noticed business meetings with a fixed agenda set out 10 days in advance. It's also virtually impossible for commissioners to thoroughly prepare for public business meetings. To prepare for business meetings of the type that the PUC has, where you have as many as 60 or 70 proposed decisions before the agency, involving each of which may involve tens or hundreds of complicated issues, it would really be necessary for the commissioners to prepare ahead of time and identify issues of concern, things that are worth discussing, different ideas and suggestions that they wanted to discuss publicly and debate. That preparation doesn't occur now because the Bagley-Keene Act prohibits that kind of discussion outside of a publicly noticed business meeting. In order to thoroughly prepare for a public business meeting, the Commission would have to have a public business meeting to prepare for the public business meeting. It's an incredibly cumbersome and virtually impossible thing to do. As a consequence, in my opinion, commissioners typically enter public business meetings without the thorough kind of preparation that I think the issues really deserve and warrant. Another problem is interrelated proceedings at the PUC. Many proceedings are interrelated today. I've cited a few examples in my paper. The RPS, LTPP, Distribution Resource Plan, Energy Efficiency, Demand Response, and Storage proceedings all are interrelated. They cannot be effectively coordinated by different assigned commissioners outside of a public business meeting because the Bagley-Keene Act prohibits it. And it's, as a practical matter, impractical to do it in public business meetings. The Bagley-Keene Act constraints are one of the reasons it takes the CPUC so long to issue formal decisions. 1.4 years on average to conclude application proceedings, 4.9 years on average to conclude investigation proceedings, 4.5 years on average to conclude rulemaking proceedings. That's all actual data from proceedings concluded in 2014. Data from other years is similar. Okay, how do we go about fixing this? I'd start with the Bagley-Keene Act. It needs to be reformed. It should be reformed. One of the reasons it should be reformed is not just that it's impairing the way the PUC functions and its ability to operate efficiently and effectively. The Bagley-Keene Act currently is not accomplishing its intended purpose. In the absence of a fair opportunity to prepare for public business meetings, commissioners tend not to discuss much in public business meetings. As a result, they become basically ceremonial affairs. Most decisions issued by the Commission are issued on the consent agenda without a word of comment about them. Some decisions are discussed on the regular agenda, but frequently only through prepared remarks that are read into the record. There's hardly ever any active discussion or deliberation in the public business meetings. As a result, the Bagley-Keene Act is creating the appearance of transparency in government, but not the reality. The Act needs to be amended to permit at least discussion of policies, programs, and priorities among members of multi-member agencies. Another important fix that would help the PUC would be to expand the existing PUC-specific exemptions that currently permit the PUC to discuss certain matters, but only very limited matters, in closed sessions of publicly noticed business meetings. I would recommend that these changes be made so long as no vote is taken and no collective consensus reached outside of the public business meetings. That way, commissioners could better prepare. I think you'd have more vibrant discussion in the public business meetings. The Act would better perform its intended purpose, and we'd improve the efficiency and effectiveness of the Commission. Ex parte. The current ex parte statutes require revision, in my opinion, too. The Commission clearly is not as accountable or transparent as it should be. The current code establishes 3 different categories of proceedings before the Commission and requires different ex parte rules for each proceeding. Adjudication proceedings, which includes complaints, informal investigations, enforcement investigations of that type, ex parte rules are prohibited. Those are treated as judicial type proceedings. Quasi-legislative proceedings are treated more like proceedings before the legislature, ex parte communications are permitted without restriction. And then there's this broad category, rate-setting proceedings. Under the statutes, ex parte communications are prohibited in rate-setting proceedings, but then there are a bunch of exceptions that seem to permit them. All party meetings are permitted. Individual meetings are permitted subject to certain notice, equal time, and disclosure requirements. The effect of the ex parte statutes and rules are significant. They've compromised transparency and accountability. They've also contributed to the communication problems within the agency. The perception is, among the PUC staff, that the commissioners, because they engage in so many ex parte communications at a critical stage of PUC proceedings, right before a vote is taken, have the feeling that commissioners are more interested in hearing from utility lobbyists than they are their own staff. That has really driven a wedge between the fifth floor at the PUC and the working levels below. That has impaired communication in a fundamental way and needs to be fixed. The ex parte rules are also complex and ripe for abuse. That makes violations more likely, it makes enforcement more difficult, and it has the effect of eroding any semblance of a culture of compliance at the Commission. I recommend several different changes to the ex parte rules. First, I think the rules should be simplified. We should structure them more along the lines of the rules applicable to other state agencies and other PUCs and federal agencies. We should use two types of proceedings, two classifications, or two categories rather than three. I'd break them down very simply into quasi-judicial, adjudication type proceedings, and quasi-legislative policy type proceedings. In the quasi-judicial adjudication proceedings, I'd flat out ban ex parte communications across the board. In the quasi-legislative proceedings that involve important policy issues and often political issues, I'd permit and encourage ex parte communications. Commissioners need all the information they can get in those types of proceedings from every different source with every different perspective. I wouldn't want to impose barriers on communications in the quasi-legislative policy proceedings. I'd also establish a clear duty on PUC decision makers to disclose any improper ex parte communications and adopt meaningful sanctions for violations. Finally, and this is critical, I'd require in some form final on-the-record en banc hearings before commissioners in contested quasi-judicial proceedings. And the reason for that is, without some kind of mechanism to offset the current effect of ex parte communications and the current reliance that many parties place on ex parte communications in order to gain some visibility for their cause, we're going to have problems creating a fair, level playing field before the Commission. The utilities already enjoy significant advantages in PUC proceedings because of their greater access to capital, to experts, and to attorneys. In formal proceedings, smaller parties, less well-financed parties that intervene only infrequently have a very difficult time even getting visibility for their issues and concerns. There has to be some mechanism to allow those parties to be heard and to gain some visibility. There also has to be some mechanism to permit commissioners to gain the same kind of information that they have been accustomed over the years to gaining through the ex parte communications. They have to hear directly from parties as well. I would do that through final on-the-record en banc hearings. Lastly, I'd like to remind you that I think the most important work that I've done over the last year has been to identify these key systemic problems. In my view, it's critical for the communications and governance issues at the PUC to be addressed. Without addressing those problems, the PUC will not have a prayer of a chance of achieving its potential. They've got to be remedied. The way to do it is through bag-leaking reform and ex parte reform. Thank you.
Thank you very much. I really appreciate you laying it out, I think, quite clearly, and these are very significant issues for a lot of different entities. Michael, are you next? Next speaker is Michael Strumwasser, who's a partner at Strumwasser and Wucher, and Beverly Grossman Palmer, also a partner at Strumwasser and Wucher. And I should note that I first met Michael in 1985 at the Attorney General's office, and you haven't taken care of this yet, so the time is now.
Thank you, sir, and thank you also, Secretary Rodriguez, for the kind recollections of a time when I had more hair. Let me just say briefly, Strumwasser and Wucher our practice essentially involves representing both public agencies and entities that, public interest groups that challenge public agencies. Many of our clients are subject to either the Bagley-Keene Act or the Ralph M. Brown Act, the local government analog to it. And so we have grappled with many of these issues for a long time. I might add also that my partner, Ms. Palmer, and I have appeared before the PUC several times, and we have litigated against the PUC with mixed results. And so this is, and I might mention that while around that same time in the 80s, I was involved in the Attorney General's office in attempting to get the Bagley-Keene Act applicable to the CPUC, and now look what we've done. We were retained by the Commission to provide an independent assessment of ex parte practices before the Commission and to make recommendations regarding ex parte practices going forward. I want to first thank the Commission and its Executive Director, Tim Sullivan, for all the assistance they gave us, and I want to thank them and also the Commissioners for respecting the independence of our charter and in producing the report that we have now tendered. Our report was made public this morning by the PUC and is now available on the PUC website, and copies are here for the panel and for the public. It's a lengthy report, and rather than try to summarize all of it in the time allotted, I'd like to focus on what we've learned from the CPUC's experience about how ex parte practices and procedures influence more fundamentally government decision making. But before I do that, I want to say one other thing. The report that you have and the findings that I will recount for you today reach back into 20 years of data, and we've talked to scores of people who practiced before the Commission, are in the Commission, have experience with the Commission. And we have, as I think you will find soon, we have uncovered some very troubling practices. I want to emphasize these are practices that have gone on for a very long time, and they should not be attributed to the current members of the Commission who would not have had a sincere interest in addressing ex parte reform had they not chosen to retain independent outside counsel. And so I would not want anything we said here to be attributed to any current commissioner. What we say here today, however, is indicative of legacy procedures and practices at the Commission that have grown up around the ex parte practices. Let me first hit just a couple of points, and Mr. O'Neill had hit them also. The basic process for making decisions in the PUC is a proceeding is opened, it goes to a administrative law judge who holds a hearing. There's a commissioner who is intermittently involved in it called the assigned commissioner. The end of that process is the production of an administrative record and a proposed decision. That goes to the 5 PUC commissioners. They decide whether to adopt it or do something else. That's in a nutshell, is the mechanism. Ex parte communications, in general, not necessarily in the PUC, but in general, ex parte communications are communications by one party without notice to or argument from its adversaries about the substance of a proceeding. I say that that's the general rule because between the legislature and the Commission's rules of practice and procedures, they managed to hash that up so badly that at the PUC you have something called an all-party ex parte meeting. As Mr. O'Neill said, the law divides the proceedings into 3 parts. I won't repeat what he said. There are adjudicatory, where ex parte communications are prohibited, quasi-legislative, where there are no restrictions, and then there's rate setting. And what is the rule on rate setting? Well, it's complicated. This is Public Utilities Code section 1701.3c. Ex parte communications are prohibited in rate setting. Couldn't be simpler, right? Problem is they didn't stop there. They then added 194 more words, starting with however, that tell you how to have ex parte communications. So here's the reality. Ex parte communications are not prohibited in rate setting cases. Substantive ex parte communications are permitted between individual parties and, on the one hand, and individual commissioners on the other, or with their advisors, the commissioner's advisors. And ex parte communications with one party sometimes, but not always, creates a right for other parties to have their own meeting. Sometimes they don't. under certain conditions that I think it's fair to say are not quite as clear as those 194 words. And the parties who have this meeting, not the commissioner, not the advisor, are then responsible for doing a disclosure to the other parties, their adversaries, about what happened. 3 guesses as to how descriptive that is. And we have this other eccentricity in the statute, which is that these disclosures may not tell other parties publicly what the commissioner said. So you have a meeting with your judge without your adversaries in which you get to know what the judge is thinking, but your adversaries don't. Ms. Palmer is now going to describe for you briefly what the data on the frequency of ex parte contacts tells us and our review of practices and rules in other similar agencies.
Thank you. We were provided by the CPUC with a database containing every record of a disclosed ex parte communication since 1992. The data demonstrates that ex parte communications are indeed pervasive at the CPUC. There were a total of over 21,000 unique reported ex parte contacts present in the database. In each proceeding, there was an average of 14.3 reported ex parte communications, but in some cases there are over 100 in a proceeding. In fact, one proceeding had over 1,200 ex parte communications disclosed. This data is consistent with what we were told in our interviews. Ex parte communications are a mandatory part of practice before the commission for the sophisticated advocates who regularly appear there. But some advocates make those communications more than others, much more. This list contains the most active parties before the CPUC between March 1992 and October 2014. All of these parties reported ex parte contacts in 27 or more separate proceedings. We normalized this data to account for the fact that some parties participate in more proceedings than others and calculated an average number of ex parte contacts per proceeding per party. The data reveals that on average, the utilities and the regulated community have significantly more ex parte communications in a given proceeding than the consumer or public interest organizations that participate in those proceedings as well. In fact, you have to go fairly past the mid-mark of the list to find our first public interest organization in our analysis, and there's only 4 groups on the list in total that advocate for public interest or consumer positions. In general, utilities have 50 to 100% more ex parte communications than public interest and consumer groups. In contrast to the intensive ex parte communications, relatively little communication takes place in the Commission's public business meetings. Over the past 6 years, the CPUC has averaged only 1.7 public business meetings per month, fewer than 21 public meetings a year. In the past year, those public business meetings have averaged just 2.5 hours. We recognize that the commissioners work hard at their jobs, but much of that work is not taking place in these public meetings. A key part of our work was to survey other agencies who have rate-setting functions, as well as other agencies within California, and determine what sort of regulations they apply to ex parte communications. We reviewed the rules of 12 different state and federal agencies, as well as a model State Administrative Procedures Act. You can see on this slide the list of entities that we studied. In general, we found that agencies' ex parte communication rules conform to the following paradigm. Where there are formal hearings as an aspect of the decision-making process, for example, sworn testimony, exhibits, cross-examination, and findings and decisions based on the record, ex parte communications are generally entirely prohibited. By contrast, informal proceedings, which could include notice and comment rulemaking, perhaps with a legislative-type meeting where the public may speak, frequently permit ex parte communications, either with no disclosure or requiring that notices be filed disclosing the fact of a communication and the content of that communication. The CPUC, however, does not fit into this paradigm under its current set of rules, most notably with regard to rate-setting proceedings, and also differs from the mainstream of practice in several other respects. In general, the rules at the CPUC permit far more frequent and substantive ex parte communications in rate-setting cases than are permitted in most other comparable agencies. And while the CPUC's governing law does require some disclosure of ex parte communications, that disclosure is far less informative than that is required in other agencies. For example, as Mr. Stromwasser just explained, the rules do not require and in fact prohibit disclosure of what the commissioner himself or herself says. We know of no other jurisdiction where a decision maker and a party can meet in private. The commissioner makes substantive statements to that party, and the other parties have no way of knowing what the commissioner said. The CPUC also differs from the vast majority of agencies in other respects by explicitly excluding ex parte communications from the record of proceedings. The CPUC is nearly alone in requiring the party making the communication to disclose the communication rather than requiring the receiving decision maker to disclose it. And the CPUC is also quite unusual in that there are no penalties in the statute or governing rules applicable to a decision maker who violates the ex parte rules. The CPUC rules also sanction the practice of using the commissioner's personal advisors, their closest staff who assist them in their decision-making process, as conduits, carrying ex parte communications from parties to the commissioners with no right for other parties to have their own meetings with that advisor. Most agencies that we studied include decisional employees within the scope of ex parte rules. That would reach any employee who is reasonably expected to be part of the decision-making process. This would certainly include the personal advisors of the commissioners. Mr. Stromwasser will now summarize for you our findings regarding the effects of the CPUC's laws and practices.
So here are the sort of the policy implications of the CPUC's experience. First of all, we have found that ex parte communications are frequent and pervasive part of CPUC practice that sometimes determine the outcome of cases. At least in some proceedings, ex parte communications influence how individual commissioners will vote. And nobody has really disputed that fact. You can tell from the fact that these organizations have large, well-staffed, well-funded government relations operations, which are largely devoted to ex parte communications, who don't feel that they're wasting their money. And it should also come as no surprise that ex parte communications are unfair to the parties. It is possible for a party to a case, and there are parties in a case who are losing cases to adversaries because those adversaries said things in ex parte communications to which they were not privy and about which they have not full information. But the unfairness of these practices to the parties are just the beginning. We found that ex parte communications before the CPUC fundamentally alters the decision-making by the Commission. It undermines the administrative record, diverting the decision-maker's attention away from the evidence in the record to non-factual policy arguments that are given exaggerated importance precisely because they are being made to people who did not attend the hearing, did not listen to the testimony, have not seen the exhibits, and do not have access realistically to the record. Let me say that again. The commissioners and their staffs do not have meaningful access to the administrative record at the time they are deciding whether to adopt the proposed decision. Small wonder then that the decision makers are grasping for ways to resolve cases without having to grapple with the evidentiary disputes in the record for which they have not been given the tools necessary to resolve those disputes. That in turn has transformed what was supposed to be a legal quest for evidence-based truth into a netherworld of negotiations between one party, typically the utility, and one commissioner, or at least one commissioner at a time, to which other parties in the public are not present and do not know what was said. This reality was underscored for us by a four-word question that we were told decision makers ask, typically the utility, in these closed sessions. What do you really need? Commissioners understand that in the hearing, the utility will ask for the sun, the moon, and the stars, fully expecting only to get some planets. In ex-parte meetings, the commissioner says, okay, which planets do you really need? Understand that what the utility really needs is exactly the subject of the hearing. What the utility really needs is what that evidence down there is all about. And that is the ultimate question in the case. And the pervasive practice of ex-parte communications at the CPUC has subtly shifted the fact-based inquiry into what do you really need into a negotiation in which the commissioner is not the judge. The commissioner is now a settlement judge who is trying to resolve a case on a basis that is satisfactory to at least the party in front of him or her. And that in turn has a tendency to elevate personal relationships and deprecate the administrative record. That was indicated by another phrase that we were told is frequently heard in ex-parte communications. You know me. Government relations representatives have understandably carefully cultivated personal relationships with CPUC commissioners and their staffs, building their trust, making it as hard as possible to say no to them and as easy as possible to say yes. And in the evidence-deprived environment in which the commissioners are making these decisions, those personal relationships take on even greater importance. Inviting a decision maker to focus not on who's on right or wrong on the record, but how to achieve an outcome that is going to be satisfactory to at least one party. Of course, these practices have flourished in darkness. These outcome determinative events have taken place outside of the administrative record, outside of the public meetings, and outside of the public view. In the process, they have rendered CPUC meetings not places where big questions of governance, of utility regulation, of public policy are debated and decided, but rather places where commissioners simply announce their votes to the public, sometimes reading a canned statement explaining a vote. I want to emphasize, I am not suggesting, and I have no reason to believe, that any of the commissioners have ever decided votes, come to a common agreement outside of a meeting. That would be a Bagley-Keene violation, and I have no reason to believe that that has ever happened. We saw no evidence of that. The collective action certainly does take place in the public meeting, but the collective action, as Mr. O'Neill said, is largely ceremonial. The commissioners don't come to meetings to decide how to vote. The commissioners come to the meeting to cast votes that they've already decided. And of course, ex-parte communications made that possible and perhaps inevitable. And ultimately, ex-parte communications have had a corrosive effect on government ethics. Numerous people we interviewed, particularly members of the staff, were deeply troubled by some of the practices that have been attributed to prior commissioners, but not very remote prior commissioners, and have recounted their concern that there has been a lack of an ethical compass at the top of the organization. It was not just the violations reported in the emails that were disclosed last year. It was an affirmative effort on the part of some commissioners to avoid public scrutiny of their actions. We were told of a loophole mentality in which the laws were navigated to avoid public scrutiny and to take full advantage of secret communications with favored parties. This ethical void was symbolized by another phrase that was quoted to us by several sources. Don't say a word. Here's what that was about. Under the prevailing interpretation of the statute that I showed you, that wonderful 194 words, some commissioners and their advisors came to the conclusion that they could have an ex-parte communication with a party that didn't have to be reported at all if the party didn't say anything. So you would have a commissioner or an advisor approaching a party, the initiative coming from the commissioner, and saying to the party, don't say a word. You need to go back into that proceeding and identify it, and you need to introduce the following evidence, make the following argument. You need to do the following in that proceeding. You didn't say a word, and then they'd walk away. And of course, per design, that was never reported. Obviously, this episode illustrates a problem with the with the state's attempt to regulate ex parte communications at the commission, but more importantly, it illustrates how the ethical rules, which more resemble a tax code than anything else, have come to corrode ethics at the top of the PUC, giving some commissioners the impression that it's okay for a commissioner to give a party secret advice in a proceeding that the commissioner is about to be the judge on how to win that case. I trust that, whatever else parties may now think about ex parte communications, that ought to be a red flag that ex parte communications have a corrosive effect well beyond fairness to just the parties. Now, we have provided in our report 28 recommendations and a detailed analysis about what should and shouldn't happen, and we'll be happy to answer any questions anybody has about those. But I want to make it clear, we do not view the end of ex parte communications and rate setting as jumping off a cliff into an unknown abyss. There are alternative ways for commissioners to get the information they need, alternatives that are widely used and successfully used across administrative law today. The key is to make meaningful use of the public process. The commission should not be meeting only less than twice a month. The commission should be meeting far more often. There's an interesting confluence and contrast between what we are saying and what Mr. O'Neill has said. We all agree commission meetings are stilted and uninformative and nothing's going on. We think that the reason for that is because commissioners have shown a preference for doing their deliberations outside, and that should stop. We agree that there should be much greater use of oral argument. Instead of having five or 6 or 7 parties have ex parte communications on a given proceeding for 20 minutes or 30 minutes with each of the 5 commissioners, there ought to be an oral argument at the commission in a public meeting, which, by the way, the law already provides for, but for reasons that nobody could explain, nobody ever uses. That way, the commissioners get a chance to hear from the parties, which they understandably wish to do, but they get to hear it on the record and before the public. And that will change this deliberation process from a deliberation between a single commissioner and a party to a deliberation among the commissioners themselves collectively. And that is what ought to happen in order to avoid substantive ex parte communications, improve decision-making, make everything more transparent. And we are convinced that requiring the PUC to do so will return it to a record-based, evidence-based decision-making that's visible to the public and consistent with the high ethics that the commission, that the public expects of this storied commission. Thank you.
Thank you very much. Much appreciated. So I'm going to screw up your pronunciation of your name, Carol. Carol Delia, sorry, Executive Director of the Little Hoover Commission. Thank you for being here.
Thank you for having me. So, as was said, I'm Carol Delia. I'm the Executive Director of the Little Hoover Commission. We're a bipartisan state government oversight entity. I want to thank OPR and the Governor's Office for convening this workshop on this important topic and for inviting the Commission to be a part of it. The Little Hoover Commission has been studying the state's open meeting laws for about a year, including the Bagley-Keene, which we've heard about already, and in particular, an amendment that was made in 2009. We've also been looking at ex parte rules of various boards and state entities. Our review is much broader than my fellow panelists who've looked just at the PUC. We looked at numerous boards and commissions that must comply with Bagley-Keene, and we also looked at various state entities that have ex parte communication rules. We also heard from a federal expert on trends in ex parte at the federal government level. As part of our process, we held 2 public hearings. We had 2 public meetings. Our commissioners, after each of these events, discussed what they heard and potential recommendations. We've recently had 2 public meetings where they specifically discussed potential recommendations, and they're meeting again on Thursday, where they will continue to have discussions and potentially adopt recommendations. So having not adopted recommendations today, I've been asked to provide an overview of what we've heard and also talk about what they've discussed, because that's all been part of public record, even though they haven't adopted it. So I want to begin my presentation today by describing what sparked the Little Hoover Commission to start looking at the Open Meeting Act. So about a year ago, in April of 2014, the Commission held a public hearing that was a follow-up on energy governance. And so at this hearing, we had the Public Utilities Commission representative, we had an Energy Commission representative, we heard from the California Independent System Operator. The hearing also featured a variety of panels of outsiders. So the final panel of the day featured the Natural Resources Defense Council, the Greenlining Institute, E3, and Severin Bornstein, who's a UC Berkeley professor. And so the commissioners at this juncture in the hearing simply said, what really are the impediments of this trifurcated energy governance system? And somewhat unexpectedly, Mr. Ralph Cavanna, who's in the audience today, said, I yield to no one in my reverence to Bagley-Keene, but one amendment a few years ago has done some real unintended damage, and I encourage you to draw attention to it, and that is the constraint on the ability of individual commissioners to talk to each other as part of the normal course of business. Two of the other panelists quickly agreed, and the consensus that day was that the difficult process of complying with changes made by the amendment that was enacted in 2009 has essentially trumped quality policymaking. Adhering to the requirements for transparency has become more important than having all the information and discussions necessary to make complex, often multi-billion-dollar decisions. Before I expand on what we learned, I want to briefly describe the amendment to Bagley-Keene that Mr. Cavanna referenced. There was a 2006 court ruling that actually affected the Brown Act, which, as you know, is the companion to the Bagley-Keene at the local level. And it regarded a serial meeting violation where a Commissioner A talks to Commissioner B, who then talks to Commissioner C. And generally, it's agreed that that's a violation of Open Meeting Acts. But the confusion of this court ruling led many to believe we needed to have some further clarifications. So in 2008, the legislature amended the Brown Act, and similarly in 2009, they amended the Bagley-Keene Act. The panelists at our hearing had singled out two words, which are a little bit different than what Mr. O'Neill focused on, but our two words were to discuss. Specifically, the new language stated, and this is a repeat of what was posted in the PowerPoint earlier, but a majority of the members of a state body shall not, outside of a meeting authorized by this chapter, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business that is within the subject matter of the state body. So again, the new words, which didn't exist before, are to discuss. Enacted with the best of civic intentions to eliminate the ambiguity of the 2006 court ruling, these words are stifling the state's ability to govern efficiently. According to one hearing witness, the confusion over the amendment has various state agencies tied in knots. And a surprising consequence, as we heard earlier, is the additional language has created less government transparency. Constraints on discussions have driven the decision-making down to the staff level and out of the sight of the public. Many participants in the commission's study process said staffers who are not accountable either through the election process or through the appointment process are making decisions which are then ratified at public meetings by the officials. More troubling, stakeholders, as we've heard in Mr. Strumwasser's presentation, who understand the constraints of the system, can talk to every member of a board or commission and learn, like bees spreading pollen, about various positions. One hearing witness, a member of a commission, told us that in some cases, everyone in the audience knows the outcome other than those officials who are voting on the matter. Everyone we heard from in our public process supports transparency. But as a result of the 2009 amendment, there's less, not more. Prior to the amendment, decision makers believed they could talk with one another informally about general policy issues related to their work, even as a majority provided that they did not attempt to reach consensus on a future action or vote. After the changes, many believed, due to legal interpretations from their government attorneys, that discussing or trying to learn about general policies among themselves risked violating the act. Today, members of state boards and commissions are left grappling with the complexities of governing a modern state while barely talking to each other outside of a public meeting. A representative from the Center for Public Interest Law told the commission that the problem with the 2009 change is the possible overreach involved in its bright line formulation of discuss that applies not just to commissioners but to intermediaries such as staff. The amendments have affected all boards and commissions, from volunteer advisory bodies like the Little Hoover Commission to the full-time boards who are making multi-billion-dollar decisions. At the Little Hoover Commission, we have volunteers. They come in for our meetings once a month. We have public hearings, and then they go back to their day jobs. So it's a lot easier for compliance. They don't see each other in the office. They rarely talk, if at all, in between meetings. But for those full-time boards and commissions like the PUC, the Energy Commission, the Water Board, these members see each other potentially on a daily basis. So we were told what they do is they don't go to the office. Why would you want to go to an office where you can't talk to anybody? One member told us. So during our study process, we heard from members and the attorneys from the PUC, from the Energy Commission, from the Coastal Commission, from the state water boards, all charged with making decisions that affect millions of Californians. We also heard from representatives from Californians Aware, the First Amendment Coalition, the California Newspaper Publishers Association, who was the sponsor of the original Bagley-Keene Act and the 2009 amendment. Now, these folks will ardently insist that the 2009 amendments have not created a problem. A representative testifying before our commission from the California Newspaper Publishers Association said there isn't anything that needs to be fixed with the Bagley-Keene Act. He said he would characterize interpretation of the existing law as being ultra-conservative by the attorneys and members who testified before the Little Hoover Commission. As he addressed our commission, he was much like I am today, standing at a table. I was up at the dais with the commissioners and watched everyone in the room as he was saying that, the attorneys who testified, the members of these boards and commissions, all shaking their head. The attorneys interpret the law the way that they do because they don't want the government to get sued. And they also don't want important decisions to be overturned by any real or perceived Bagley-Keene violation. The Little Hoover Commission's body of work is guided by principles of accountability, transparency, and furthering the public interest. We believe wholeheartedly in open government and that the public should have a seat at the table in decision-making. And it's with that spirit that our members have consistently discussed recommending that the legislature adopt minor modifications, new language to clarify that officials appointed to state boards and commissions can hold informal, internal discussions among two or more members about general policy issues related to their work, as long as those discussions are not used to develop concurrence or consensus on an upcoming vote or decision. Over the course of the year, the Commission also looked at ex parte. We examined the everyday use of private conversations in the executive branch between government officials and the interests they regulate, so-called ex parte communications previously described by Mr. Strumwasser. This became a significant concern as we did our study, as revelations and allegations that some PUC officials had unreported and illegal conversations with the utilities they regulate. As a result, there's legislation proposed that would provide stricter control on ex parte communications at the PUC. Again, our commission was not looking as deeply at one entity. We were looking much more generally and considered whether these private conversations between regulators and the regulated are appropriate. We looked at the array of rules by various agencies throughout state government and, as I mentioned, also the trends at the federal level. The Commission concluded that these private conversations are, in most cases, a necessary and effective tool of information gathering and governing. The downside is a public perception that influential interests run the table as a result of these conversations. But the truth is it's also a two-way street in which regulators gather relevant information that can lead to smarter decisions. The Commission is not convinced that tightening the rules will change the culture that led to the alleged illegal conversations, and potentially worries that it could have unintended consequences of making it more difficult for the regulators to make informed decisions. For the Commission, this is consistent with previous recommendations. In 2009, the Commission looked at the state water boards, and at that time, there were constraints on the state and regional board members' ability to communicate with their regulated entities. The Commission recommended that communication should be allowed, and amendments were made to ex parte rules for the water boards. The Commission found that the rules that were in force at the time made the board members unapproachable and also undermined the stakeholder confidence in the board's regulatory system. So our experience has been that when communication can't happen, it leads to lower quality decision making. In short, the prohibitions on contacts between regulators and the regulated showed a lack of trust and lack of understanding on why the boards made the decisions that they did. So in alignment with this prior recommendation, the members of our commission have discussed recommending that the state retain its array of ex parte policies that provide useful information to executive branch decision makers that govern a variety of proceedings. But at the same time, our commissioners have discussed ramping up, broadening disclosure requirements. And this could include making sure that there's a full and complete summary of what was said and making sure that that's put online so that it's there for all to see. Our commissioners have discussed and likely will continue to discuss on Thursday the costs and benefits of doing that and where the burden should be. Should it be on the regulator or the stakeholder who requested the conversation? And should there be an ability of the regulated, if it's the regulated who provides it, to then be able to ensure that there's a supplemental filing if all of the information is not adequately disclosed. So as I stated earlier, our commission will be discussing this further on Thursday and potentially adopting recommendations. If in fact that happens, we'll have those recommendations on our website as shortly after the meeting as possible. I want to thank you for including me today, and we're ready to support the governor's office and assist in any way. Thank you.
Thank you very much, and thank you to all three presenters. I think it's the set of issues has been quite clearly, in some cases, starkly set out. What I think we want to do now is take about a 15-minute break. We'll then hear from 3 state agencies and public comments. So it's 10:10. Why don't we come back at 10:25? Thank you very much.
Well, that's because the first one jumped Yeah, oh, thank you. Yes, yes, yes. Yeah, that's right. Yeah, I You knew that.
you.